U.S. chipmaker Qualcomm has filed a new lawsuit against tech giant Apple in China. The suit asks Beijing Intellectual Property Court to ban the sale and manufacturing of iPhones in this country. The announcement is the latest move in a patent row between the two companies. The lawsuit is based on 3 non-standard essential patents covering power management and touchscreen technology called Force Touch that Apple uses in current iPhones. Qualcomm claims Apple is using its technologies without paying for them. Apple began the legal battle this year by filing an antitrust suit against Qualcomm. Apple argues that the chipmaker's licensing practices are unfair. Qualcomm has countered with patent infringement charges against the tech giant. Very complicated, very nasty, a fight over there. What could be the outcome of the battle of the tech giants? Qualcomm against Apple. Let's turn to our panelists. Probably they can figure out the answer for all of us. With us here in Beijing, Edward Lehman, who is the Managing Director of Lehman, Lee and Xu on IPR. Welcome, sir.
Good
also in Washington, D.C., we are joined by Bruce Fein, who is an attorney and law firm associate. And also, meanwhile, we are joined via Skype in Salt Lake City. Good to see you, Jay Huang, over there in the United States now this time. He's the founding partner of Jadestone Venture and also former managing director of Intel China. Gentlemen, I want to thank you to come to our show for this complicated, fascinating issue. Okay, Edward, you're dealing with IPR every day.
I am.
This is nothing new to you,
No.
but certainly fascinating.
Yeah.
What's going on?
Well, you know, it's a patent case. It's a contract case wrapped up as a patent case, in my opinion. I think that Qualcomm is a 900-pound gorilla, and they would like to get their patents paid for, and they're bringing this lawsuit in order to because Apple has said that they would not pay for them, and that's why this suit is begun. And then there's a bunch of suits that are going on around the world. It's kind of a lawyer's full employment act, but it's really a contract dispute that has to do with patents, in my opinion.
Bruce, what is your judgment? If Qualcomm is 900-kilo gorilla, what about Apple? Probably more than that. So what about this wrestling this time?
Well, I think it's right. It's about patents and contracts, also a little bit of antitrust, because patent gives you an automatic monopoly over the particular product or service that's entitled to patent protection. It's clearly just over money, if you will. That's what patents are about.
Right.
And licensing patents and contracts. How much are you paying for a product or service that you need? Now, the remedies sought are typically damages. You know, how much profit, if you prove patent infringement, was the infringer gaining from the use of your intellectual property without paying for it. It's rather drastic and very unusual to have an injunction against producing the product at all that's thought, you know, more harmful to the consumer who would like to buy the product.
Right.
But in terms of length of time, too, Apple and Qualcomm are so wealthy that if they want to push appeals, they'll probably go to the United States Supreme Court if they're sufficiently diligent in pressing their case, and that means unless they settle, this could be a 5- or 10-year battle.
Right, it could be, probably even longer, if they really want to make it a battle as long as that. Jay, though, I'm not sure whether they really want to do that or there's something else that they want to talk about, usually.
I think Qualcomm made a very strategic and smart move on this case. As we all know, the main battlefield is in the United States court. So Qualcomm started the second battlefield, which is in China. If Chinese court rules in their favor, which is a very big if, and that means Apple has to stop their manufacturing in China, which is the only manufacturing place in the world, so it would be very detrimental for Apple. On the other hand, if Chinese court doesn't rule in their favor, and since they bring up a different patent, as you correctly pointed out, those are not standard essential patents. So Chinese court ruling will not have any significant impact to their battle in the United States. I think that there is an unexpected winner potentially, which is the Chinese court, because never happened in the history. 2 U.S. giant and technology firms face Right now in the Chinese court, this is unprecedented.
3 Chinese companies, in fact, we have seen in history, have sued Apple before, for different reasons, of course. The first, the 3 Chinese companies to sue Apple took issue with the word iPad. Back in 2012, China-based company ProView Electronics sued Apple for $1.6 billion. Zhizhen Internet Technology then sued Apple for infringing its voice assistant service patents, and then Jiangsu Xuebao filed a lawsuit against Apple over a trademark on the operating system Snow Leopard, and also many other incidents. But having said all of these, this is nothing when we talk about the scale between, this time the Qualcomm, Edward, and Apple. And
yes.
Also, this has
Could
never
I
happened before.
Offer this observation?
That Qualcomm and Apple, 2 American companies, trying to seek out a solution through a Chinese court, Edward.
Yeah, well, I mean, I think it's optimistic that they're trying to seek it out in China because, I mean, as was pointed out, that they're manufacturing here,
right,
and this is the point.
According to Jay, it was only a preview of the even nastier battle and the bigger battle.
Right. No, and I think, I mean, there's been precedent for that as well. I mean, that they're with Samsung and Apple when they were trying to stop, customs and importation or sale of the products. So, I mean, that's why they're trying to get attention. But I think this is a big chess game, and one of the components of it now is China. It's a $145 million lawsuit as opposed to a $1 billion+ lawsuit in the United States. And it's also being litigated in other parts of the world, is my understanding as well. And it all started in Korea, actually, with the Korea Fair Trade organization, and that's when they were not paying. Apple wasn't paying at that point in time. So this has gone around the world.
This is very exciting to journalists like us, Bruce. So how are we seeing the chess is likely to be played from now on?
Well, this is one of the things. I'd been involved in some antitrust litigation against first IBM and then AT&T when it was the sole long lines provider. And by the time the cases ended, technology had overridden what was relevant at the time. And I don't think we should understate the possibility that in a couple years' time that Apple or some other company has invented around the Qualcomm patents, and it makes moot the whole lawsuit, except, I suppose, for damages in the interim. But I think that's typically what happens in these highly developed and fast-changing tech areas where they proceed by warp speed, and something that looks essential today, tomorrow it looks obsolete. And in my judgment, given the progress in the IT world, that's probably going to happen given the length of litigation, which is lead-footed. It is not mercury-footed.
Bruce, it's a great point. But on the other hand, Jay, I mean, you think about the lawyers for Apple and Qualcomm. Of course, they know this. They know that at the time when probably the suit is settled, it's already the time when the technology is not the hottest, is not worth the most money. They know that, but why do they still want to pick a big fight? Why do they still want to pick a big fight here in China? I think that is the issue, Jay.
You're absolutely right. I think that there are a lot to do with the way and Qualcomm collecting and their loyalty fee on their patent. Usually, the big companies that are cross-licensing each other's standard essential patent. For the Qualcomm case, and they're actually one way, just like collecting the money, not paying the other. And also the way they're charging their patent is based on the the smartphone, the total selling price on the percentage of that. Say, for example, if you put a diamond on the smartphone, and the Qualcomm will have a share of that piece of diamond value. So this kind of royalty payment is very irritating to a lot of industrial vendors. So if we can say each company and have a lot of enemies, we can definitely say, and there's a lot of companies they don't like Qualcomm much more than they don't like Apple.
Edward, so here in China, how is this lawsuit likely to proceed? Help us understand it legally in plain terms, please. And also, according to the Chinese law, the IPR is quite a new issue, shall I say. So with the amount of the legal issues that could be handled by the Chinese court, which direction should we examine from now on, Edward?
Yeah, I know. I mean, the way you're looking at it is different here. We have a civil law jurisdiction as opposed to a common law jurisdiction. We're not bound by case law. We have a relatively new legal system under the intellectual property laws, policies, and regulations. What will typically happen is that they brought this lawsuit. Now they're going to probably move, I would imagine, to invalidate the patents. Essentially, Qualcomm has patents that are taking that are being used in all 3G and 4G technology to take data and crunch it down to be able to use on radio or on audio, and that's what it's all about. And then the question is what's essential and not essential. So I assume that the next step would be to try to disqualify some patents. So it's, again, a sort of a chess match. This is not going to be mercurial, and it's not going to be as lead-footed probably as the United States. It moves rather fast here, the docket, compared to the United States.
I see.
But it's still going to be a long process on invalidating the patents, whether that will come up next, and then come back to the issue of the Qualcomm suit. That would be my guess on how it was going to go forward.
Interesting. Jay, on the other hand, I mean, you used to work for a chip maker. I mean, for Intel, for example. Of course, there could be some competition between Intel and Qualcomm, but on the other hand, you know, how is that demonstrating to us, this specific lawsuit, in China particularly, the relationship between the chip maker and now all of these gadget makers that are really fascinating the world market? How is this telling us about that story?
I think your guess is absolutely right. You know, Qualcomm, for example, their innovation, their patents run on the telecommunication and the telecommunication chips. Now, if you look at today's smartphone, it's more than just a phone, because for the phone, telecommunication is a crucial part. Now the smartphone is truly a portable computer. And then there's a lot of you know, innovation added on to the telecommunication part. Now Qualcomm claim and then thinks I'm the patent owner for 3G and 4G, so I want to charge based on the whole thing. So this is the fairness and coming from. And another one is that they do own standard essential patent for 3G, perhaps some of the 4G. Now we're moving towards the 5G, so why are you still charging us and then using that way? So this is an issue. I think that one of the beneficiaries from all those and the patent dispute is a Chinese legal system. I think this is an opportunity for them and to have exposure to the IP and, you know, legal battle and on the global arena. So I hope and also I believe that they're going to gain quite a lot of experience, and then this is going to help China to better establish our IP protection in the Chinese court for the Chinese companies and also for the Chinese company going abroad.
Very interesting. Bruce, what about your assessment? I mean, how is this demonstrating the changing of the industrial landscape, in fact, that we are talking about between telecommunication and also, you know, companies like Apple? And how is this likely to make an interesting case study? Comparison, for example, China, United States, also help China to learn. What is going to be that learning curve? A long list of questions, but all of those important. I want to ask you, Bruce.
Yes. Okay, I think the first point is an excellent one, and that is as the patented data or the patented invention is incorporated into something well beyond just telecommunications, then you get the issue of whether or not you're illegally extending the patent when you charge the revenues based upon the entire product rather than just on the features that your patent is contributing to. And that's one of the theories of the violation, that Qualcomm is asking for revenues based upon the entire iPhone, even the parts that really aren't needed from Qualcomm to make it consumer friendly, if you will.
Right.
A second element I think that's kind of a landmark here, we have proceedings both in China and the United States and elsewhere. And the likelihood is substantial that there may be conflicting rulings based on these different jurisdictions as to whether the patent was infringed, and if so, should it be banned or should it just be damages payment. And the international law here is quite murky with regard to the international enforcement of civil judgments, and whether or not we will end up with some jurisdiction determining whether the due process, the fairness of other jurisdictions was sufficient to justify entering their judgment as binding in an outside jurisdiction. For example, suppose that the China court, because it moves faster, enters a judgment first. Say it enters it in favor of Apple. Are the United States bound then to respect that judgment and stop their cases, even though we're only at the infancy? Or they may say, well, Chinese, they don't have enough procedures. So that clearly is going to be a landmark element in this particular litigation.
This is, in any way, when you examine it, fascinating, to say the least. But I want to thank the three of you. Tap into your expertise about this. Jay Huang, Bruce Fein, Edward Lehman. Really, thank you.
Thanks, Tim.
The three gentlemen, for being with us.